To whom, as we've had for most of the night, I think we can probably agree on both sides of the House that this is a good and necessary piece of legislation which will provide a high degree of consumer protection. And indeed, if you look at it's very akin, I suppose, to the old Real Estate Act, an act that was way out of date, needed modernisation, and the House generally came to the party to bring it into the 21st century. I just will make one comment, if I may, slightly off the bill, but pertaining to the former Speaker's dissertation, and it's this. It was Ms Shanks who said that this current government keeps its word. I just say this to her. Maybe on some things, but not with GST. If we look at this piece of legislation, moving back to the bill, one of the things, when I was Building and Construction Minister, and had a hand in this, but Mr Jones and latterly Mr Heatley saw it through. One of the things I recall that was a major problem was the unanimous requirement for body corporates to agree, that unanimity, to basically get anything major or even minor done. This bill, of course, corrects that, and you need a 75 majority. So the objective, I recall, with that clause or that piece of the legislation was to stop some of the examples of what I think were colloquially called holdouts, where in many cases maintenance had to be done in a unit title of, could be 10, could be 50 units, and there would be one person. This was very prevalent in leaky buildings. I recall one case where I think the whole series of unit titles had agreed, apart from one gentleman who resided, I think, in Spain, who rented his particular unit, so the story went, and decided he was not going to pay or participate in anything or put any money up as a contribution to remedy the situation. So that particular block of flats or apartments, I think in Auckland as it was from memory, was stymied. They couldn't do anything. Every unit title owner, apart from one, had agreed, and it was self-evident, nobody disagreed, I think, that maintenance and construction work was needed to be done to remedy the leaky building situation. I think they were then going to proceed to court, but they wanted to get that fixed. And it was one particular unit title owner who resided overseas, a Kiwi, who just said, no, I'm not interested, I'm not coughing up. I'm not going to vote in favour, because that would have been a binding resolution he would have been forced to make, I think, a relatively, from memory, small contribution to the overall maintenance fund. And that, certainly some years ago when I recall that case, those people were left effectively languishing and couldn't affect repair or protect or advance the protection of those block of flats. So I think that is something that was not, I suppose, anticipated in respect to the Act in 1972, because of course we didn't have the so-called leaky building syndrome. I think one of the other things that, leading on for that, which is impressive about the legislation which will provide protection, is the need for the establishment of long-term maintenance plans to protect the long-term value of the development. Now that on the surface again may seem quite self-evident, why wouldn't you want to do that? But again, I think there were cases of holdouts, again unanimity required, and in many cases there were not, if you will, in smaller unit titles, the skill base of owners, or there was a lack of, because of body corporate fees, lack of resource to actually gain advice and skills that were necessary to advise on maintenance plans. So things just slipped, and the roof that may need replacing and may have needed some maintenance slipped to the point where there was a requirement at one point for each of the owners to dole out a large lump of money to remedy a major problem. And of course this was difficult for those who were purchasing, because one of the other pieces of I think excellent work in this legislation is the requirement for disclosure, both financial and also things like the body corporate minutes, so that a potential buyer can go in and examine those documents, because those body corporate minutes can be very revealing in terms of the history of the building, in terms of its value, in terms of have there been any structural or maintenance problems with it. They can be very revealing to a potential buyer. And if the body corporate previous to this piece of legislation, if the body corporate of course wished to, they could block access to those documents. I recall, I think you have to get currently the body corporate's permission to inspect those documents. So this bill I suppose there's another, and it does remind me, as I say, somewhat of the real estate agents legislation. It is a good solid piece of consumer protection legislation, because there is an argument that everybody, of course, should be responsible for themselves, and that's predicated on the myth that we all have the skills to analyse these situations and to know what the questions to ask and to gain the information we need. Well, the truth is, and I include myself in this, many Kiwis do not have a monopoly on knowledge. They don't have the skills. They don't have the right questions to ask. They are good-natured people of good faith, but they get sucked in by sharks. And we need legislation. Of course, they are ultimately responsible for their decisions, but we need legislation, I think, simple rules to provide those consumer protections, to force disclosure of vital information, that in the ordinary course of business, I would argue, most body corporates, good-natured as they are, appropriate as they are, would avail a prospective buyer of that information anyway. However, the sad thing about legislation, of course, in this House is we tend not to pass legislation for the 99% of people who will obey the law, really, whether it exists or not. We tend, and we have to, sadly, deal with the lowest common denominator and protect the people from the 1% or 0.1% of folks who are hell-bent on ripping good folk off. So there is, of course, in here, as I say, disclosure provisions. Equally, there is the ability with this legislation for disputes to be dealt with through mediation and adjudication in the tenancy tribunal in the first instance, rather than solely rushing off to the courts, therefore making resolution, I would argue, faster and cheaper. The courts are often an option, if we focus for a moment on the leaky building scene, courts are often an option for very, very large bodies, corporate, with a large budget, because there are so many members contributing to that, that often the larger ones, and they are today, of course, will proceed directly through our court system and gain a judgment. They have the resources to do that. They have the resources because of numbers and body corporate fees to gain the experts they need. However, if you're in a body corporate of, say, 10 or even 20, you don't have that ballast, that financial capital, that capacity to wander off into a court and perhaps get justice in a swift fashion, but it costs you a bucket load of money. And often disputes begin as minor disputes and fester, and there are many cases, I'm sure, as constituent MPs on both sides of the House we have dealt with these. They fester into large legal disputes and arguments, if not dealt with. So I think the legislation providing for mediation and adjudication, a modern form, Mr Speaker, a modern form of dispute resolution in this day and age, an alternative to courts, not to usurp courts, but an alternative, I think will provide for, those smaller body corporates especially, to be able to resolve disputes cheaply, efficiently and swiftly. That is a major problem that we have. So look, I support this legislation, Mr Speaker. I also note my colleague Shane Jones noted with some pride that the legislation also brings the infrastructure into the 21st century. We of course now will have with this legislation computer registers, the creation of a computer register where land is subdivided to create the unit title development, the creation of a computer register where the principal unit subdivided to create a subsidiary unit title development. The use of technology, again, an attempt to cut down the red tape, to use the technology to have swifter and more efficient outcomes. So I think in summary, sir, to conclude, we on this side, despite the sort of, who did what to whom and where and the, who takes the credit for what, I think tonight is one of those times that that the people will look at this chamber and perhaps agree that a bit of bipartisanship is always appropriate, especially when it comes to consumer protection. At the end of the day, your unit title, just like your freehold property or a standalone house, is probably the biggest asset that Kiwis will have in their lives. It's one where, especially with a unit title, where there is common property and there are risks that are different and often greater than a standalone house. So I think this will provide the protection. I endorse the bill, sir.